2023 CR 0684, State of Texas versus Demetric Deshaun Jackson. Can I have parties announced for the record for the state?
Travis Banks in the state of Texas.
Defense.
Lalo Garza for the defendant.
All right, you entered a plea on April 19th of no contest, and you applied for probation, and you entered a plea on the offense of assault, family choking, strangulation. Punishment is to be assessed at a cap of 7 years. The state opposes your application.
From the very beginning, this case is heavy. We're not talking about a minor dispute. This is assault involving choking, which the law treats as extremely serious because it can turn deadly fast. The fact that the state immediately opposes probation tells you this wasn't viewed as a close call.
Can you tell the court why you think you should be getting probation?
I'm very deserving of a second chance, and I want to be more helpful for my kids. It helped me stay more focused while I'm trying to rebuild what I lost.
And then you hear the familiar argument, I want to be there for my kids. Judges hear this every single day. Wanting to be a better parent matters. But the courtroom isn't built on wishes. It's built on accountability. What matters most is whether the person actually accepts responsibility for what they did.
I believe you told me it was purely an accident, correct?
Yes, sir.
Did you have any relationship with this woman?
No, sir.
Wait a minute, I'm sorry.
Okay.
He's pled to assault choking, is that correct?
That's correct.
I don't understand how assault choking is accidental.
Oh, you talking to me?
Yes, because you're saying it was an
Oh.
accident. I don't know how you choke someone accidentally.
Oh, no, it was a misunderstanding. It was a misunderstanding.
How is choking someone a misunderstanding? And mind you, I'm just trying to figure out what you're trying to tell me.
Yes, ma'am.
So I don't understand how choking someone is an accident or how choking someone is a misunderstanding. Now, if somebody said, choke me, and you thought you heard them say choke me, and then you proceed to choke them, I can understand, oh, that's a misunderstanding. I thought you were telling me to choke you, but you didn't. So I'm trying to figure out where.
This is where everything starts to fall apart. The judge isn't being rude. She's being logical. Choking someone isn't an accident. It's not a misunderstanding. And the more the defendant tries to explain it away, the worse it sounds. You can hear the judge trying to understand, but the explanation just doesn't make sense.
You said that this was all a misunderstanding, and I was reading in the PSI that you also said she did it to herself. Did you recall telling the PSI person that she did the choking to herself?
Yes, ma'am, because I didn't touch it.
Okay, so it's your position that she choked herself.
Yes.
Okay.
This moment is honestly shocking. Saying the victim choked herself completely destroys credibility. Once a judge hears that, it signals denial, deflection, and zero accountability. At that point, probation becomes almost impossible because probation requires honesty and responsibility to work.
State.
Your Honor, I think according to the PSI, he has been on probation many times. He's been revoked from probation many times. I think he's come to the court and he's misrepresented his criminal history. Furthermore, he's minimizing his guilt. He says that he didn't do it. He says it's a misunderstanding. He even told the PSI officer that she choked herself and that any injuries she might have had, she caused to herself. I will also point out that to the extent that defense tries to argue he had a rough upbringing, he told the PSI officer that his childhood was blessed and that he doesn't need any kind of drug treatment. He also said he doesn't see how probation is going to help him, but he'll try. I think this is someone who doesn't want probation, doesn't want the kinds of services that are available to help improve somebody's life while they're on probation. And for that reason, the state is asking that you meet the cap at 7 years.
The prosecutor ties it all together. Minimization, past probation issues, inconsistent statements. This isn't just about one incident anymore. It's about a pattern. And when someone comes into court still blaming the victim, the system takes that very seriously.
This case has been going on for quite a while. He hasn't been in any further trouble, Your Honor. Right? I think this was an incident that occurred because I think the lady thought and she had a relationship with him and he did not want to. We're asking the court to put him on probation. I believe he knows that probation will help him. He'd like to do what he can to get a job, do what he can for his family, and be there for his family. So we're asking the court to.
The defense does what they can: family, work, time passed. But good intentions can't outweigh the facts, especially when family violence is involved. Courts prioritize safety over sympathy.
Mr. Jackson, I want you to know, I did look at everything. I just don't think that you're a good candidate for probation. What I'm going to do is find you guilty, and the previous judge found you guilty. Going to sentence you to $500 fine, time and money run concurrent. There's an affirmative finding of family violence. There's to be no contact with Elizabeth Dahl. Take in consideration 2020 CR 2357, and I'll sentence you to 6 years in the prison. Give you credit for any time served.
Clip 7. The final decision is clear and firm: 6 years, no probation, and an official family violence finding. This sentence isn't just punishment, it's a message. If you won't take responsibility, the court will step in and do it for you.